Good afternoon, everyone. Thanks for coming out this afternoon. My name is Chadzutko. I'm the president of the Federalist Society here at New England. And today we've got a great panel for you on predator drones, targeted killings, and the law of armed conflict. I think it's appropriate that we're addressing a subject like this on the 236th anniversary of the Battle of Lexington and Concord, so actually the true Patriots Day today. And I would like to thank our panelists, Professor Hansen, Professor Lewis, and our moderator, Professor Friedman, for agreeing to participate in this today. I'm going to introduce Professor Friedman now, and he'll take the stage. So Professor Friedman teaches constitutional law, information privacy law, national security, and state constitutional law here in New England. Before joining the New England faculty in 2004, he was a visiting assistant professor of law at Boston College School of Law and a lecturer on law at Harvard School of Law. He was recently appointed to the Boston Bar Association's task force on the future of the profession and is a former member of the Boston Bar Council. In addition, he is currently president of the board of directors of Massachusetts Appleseed, a center for law and justice that has several ongoing projects related to educating homeless children, keeping kids in school, and reducing the incidence of juvenile delinquency. He has served as a law clerk with the New Hampshire Superior Court and then as law clerk to the Honorable John T. Broderick Jr. of the New Hampshire Supreme Court. And with that, I'll turn it over to Professor Friedman.
Thanks, Chris. Hello. Good to see so many people here, as always. And right now, so I don't forget, I want to thank Chris. This is the last Federalist Society event of the year. It has been a terrific year of events and speakers, and I hope you'll all join me in giving him and his executive board a hand. I have the easiest job in the room. I just have to make sure these two don't hurt each other. To my right is Professor Michael Lewis. He's a professor at Ohio Northern University's Pettit College of Law, where he teaches international law and the law of armed conflict. He spent over 7 years in the United States Navy as a naval flight officer flying F-14s. He flew missions over the Persian Gulf and Iraq as part of Operation Desert Shield, Desert Storm, and he graduated from Top Gun in 1992. After his military service, he attended Harvard Law School and graduated cum laude in 1998, and he has lectured on a variety of aspects of the laws of war, with an emphasis on aerial bombardment at dozens of institutions, including Harvard, NYU, Columbia, and the University of Chicago, in addition to publishing several articles and co-authoring a book on the laws of war relating to the war on terror. And to my far right, my colleague Victor Hansen, who teaches criminal law, criminal procedure, evidence, and prosecutorial ethics here at New England. Before joining the faculty, he served a 20-year career in the Army, most of that time as a JAG Corps officer. In his last military assignment, he served as a regional defense counsel for the United States Army Trial Defense Service. His previous assignments include work as a military prosecutor and supervising prosecutor. He has also served as an associate professor of law at the Judge Advocate General's Legal Center and School in Charlottesville, Virginia, and he is the author of several articles and books on criminal and military law evidence and national security issues, and is an elected member of the American Law Institute, which you have to take it from me as a very cool thing. All right, Professor Lewis is going to get us started. Each of our panelists is going to speak for 15 minutes, and then they are going to take your questions.
Okay, I'm going to begin by talking more on the international law aspects of the use of drones, and specifically the argument or the discussion that's come up with regard to the U.S. use of predator drones in targeting individuals outside of Afghanistan or Iraq. There was a lawsuit that was filed about 9 months ago by the ACLU in the case of Anwar al-Awlaki, who is an American citizen, and I think that Professor Hansen is going to deal a lot more with the domestic policy issues and separation of powers issues and that sort of thing that also arise from this lawsuit. But I'll kind of preview it for you a little bit. They say al-Awlaki is an American citizen, and so how can you possibly target him for death without giving him due process first? He is in Yemen, and this is where I step into the argument. They're saying he is not within what they describe as the zone of armed conflict. And they say because he's outside of the zone of armed conflict, you have to use law enforcement tools to capture him. You can't use the tools of armed conflict. And this is based upon the idea that the armed conflict is definable by geopolitical lines. There is a war in Afghanistan. There is not one in Yemen. Mary Ellen O'Connell at Notre Dame, who was one of the chief advocates of this theory, would even go so far as to say there is a war in Afghanistan, there is not a war in Pakistan. And to the extent you want to use predators across the border in Pakistan, certain situations have to apply that aren't necessarily obvious, that you're going to need Pakistani involvement, and you're going to need a threshold to be reached within Pakistan that may or may not be there. And I disagree strongly with this idea that the boundaries of the battlefield should be geopolitically defined. And that's because traditionally that's not how we have described the boundaries of the battlefield. It's traditionally been that the law of armed conflict goes where the participants in the armed conflict go. And it doesn't matter whether you are 500 or 1,000 or 10,000 miles from where the fighting's going on. If you are a member of an enemy force, then you can be targeted wherever you happen to be. Now, in order to understand why I say this, I think it's important to get a little bit of background on how the law of armed conflict looks at participants anyway. The participants in armed conflict are divided into two groups. There are civilians and there are combatants. Combatants are defined as those people who belong to an organization that enforces the laws of war. And so that means, for example, that U.S. soldiers are combatants because they belong to an organization that has a hierarchy that enforces the laws of armed conflict. If you violate the laws of armed conflict, we will prosecute you for that. In fact, just 2 or 3 weeks ago, we sentenced a couple of individuals to 20-plus years in jail for murdering Afghan civilians. They're our soldiers. They violate the laws of armed conflict. We enforce the laws of armed conflict. The advantage of being a combatant is that you get what is called the combatant's privilege, which means that the harm that you do, as long as you're obeying the laws of war, is not something you can be criminally prosecuted for. So you blow up a building and hurt the people in it. Under Massachusetts law, if I blow up the building over there, I would be charged with malicious destruction of property and arson and murder and mayhem and assault, etc. If I'm in Afghanistan and I do that, and I am fighting the Taliban and I hit the building that Taliban are in, I may kill civilians. It may be a civilian building, but I cannot be charged under Afghan law with malicious destruction of property, etc., as long as I obey the laws of war in executing that attack. That's what the combatant's privilege means. Now, everyone who is not a combatant is a civilian. They're kind of negatively defined. All that are not combatants are civilians. And all Al-Qaeda are civilians, because they are not members of an organization that enforces the laws of war. In fact, they're members of an organization that actively subverts the laws of war by targeting civilians and doing other things, blending with civilian population, that you are not supposed to do if you are obeying the laws of war. And so they are all civilians. The advantage of being a civilian is that you have civilian immunity. You may not be directly attacked, you may not be the target of attack. But the disadvantage of civilian is you're not allowed to participate in armed conflict. You're not part of this. You can't pick up a gun and start shooting at people. If you pick up a gun and start shooting at people, you don't become a combatant by doing that. You become a combatant by joining an organization that enforces the laws of war. You pick up a gun and start shooting, what you are then is a civilian that is directly participating in hostilities. And because you're directly participating in hostilities, you forfeit your civilian immunity. And there are two ways of forfeiting your civilian immunity. Temporarily, through direct participation. I pick a gun up, I start shooting, I put the gun down, I walk away, I'm a civilian again. And you can't target me. However, if I do this repeatedly, if I pick a gun up every night, if I farmer by day, fighter by night, if I do this regularly, or if I'm in a leadership role, even if I'm not actually firing a gun, but if I'm in a leadership role of an organized armed group, then I'm considered what's called a continuous combat functionary. And once I take that role on, I have forfeited my civilian immunity 24/7. I can be targeted whether I'm in my field farming by day or carrying my AK at night, because I carry my AK every night. And because I do that regularly enough, I become functionally like a combatant for targeting purposes. So I can be targeted 24/7. And this is what the Geneva Conventions and the laws of war have done. This is how they judge terrorist organizations. They deny them combatant status because they don't enforce the laws of war, and they deny them civilian immunity for such time as they are involved in attacks, or if they are a regular member of a terrorist organization that consistently does this, they lose their civilian immunity entirely and are targetable. This is how the laws of war treat terrorist organizations. Now, what does that have to do with the boundaries of the battlefield? Well, the other thing to understand about the boundaries of the battlefield is how they were traditionally understood, and that was, as I said earlier, law of armed conflict goes where the participants in the armed conflict go. And a very good example of that is the Graf Spee incident from World War II. The Graf Spee was a German commerce raider. It was a pocket battleship that had sunk about a dozen British merchant ships throughout the South Atlantic and Indian Ocean. And it runs into a group of British cruisers off the coast of South America, and after an exchange of gunfire, it ducked into the port of Montevideo in Uruguay. Now, Uruguay was neutral in World War II, and so the British Navy could not pursue the Graf Spee into the harbor and sink it there. But because Uruguay was neutral, the Graf Spee couldn't stay. It was allowed to stay as long as any other ship would for refueling and refitting. But once it was seaworthy again, it had to put to sea. 72 hours was how long the Uruguayan government gave the Graf Spee. And rather than going out and fighting a numerically superior British force outside the harbor, the captain chose to scuttle the ship in the harbor. And then the crew of the Graf Spee were interned by Uruguay and held there for the balance of the war. And this is exactly the position that Yemen should be in with regard to al-Awlaki. Al-Awlaki, the Yemeni American citizen who we are targeting there with drones. They should be in a position of either being neutral, an ally of ours, or an enemy of ours. If they're an ally of ours, they can say, sure, go ahead, use the tools of armed conflict on our territory. It's their sovereign territory. They can allow us to do that. If they say so, we may use the tools of armed conflict on their territory. And that's what happened in 2002 when we used a drone to kill an al-Qaeda member in Yemen. Or they could be an enemy. They could take the position that the Taliban took with us after 9/11. No, you can't have him. You cannot have Osama bin Laden. And because of that, when we invaded Afghanistan, we were not only going after al-Qaeda, but we were going after the Taliban as well, because the Taliban had taken sides. That would be like Uruguay saying, no, British Navy, you're not allowed in here. The Graf Spee can stay in here as long as it wants. And the British would say, no, you're wrong. If you are going to defend the Graf Spee, you are taking sides, you're aiding a belligerent, and we were allowed to come in and sink that ship, and we're also allowed to sink whatever Uruguayan ships try to prevent us from doing so. And then the third option would be for Yemen to say that they're neutral. That, no, you may not use the tools of armed conflict on their territory, on our territory. They're a sovereign nation. If they say that, we must respect that. That there is a minor self-defense argument, which I don't think applies here, and we won't get into unless you want questions. But generally, they say we can't do it, we can't do it. It is their sovereign territory. However, if they're going to be neutral, then they can't let al-Awlaki stay. They have to either intern him, capture him, arrest him, hold him, or kick him out of the country. They don't have to turn him over to us, but they have to get him out of their country so their territory is not being used as a base of operations for al-Awlaki and the rest of AQAP. And those are the three choices that they should be put to. Now, if we take the ACLU or O'Connell argument that the boundaries of the battlefield are Afghanistan, but not Yemen, what you're effectively doing is saying to terrorist organizations, there is a sanctuary for you. You have a safe haven. Get to Yemen, get to Somalia, get to Sudan, a place where law enforcement is not effective. The tools of armed conflict may not be used on you because you are outside of the zone of conflict. And if you're outside of the zone of conflict, you can't be targeted. And the reason why this is so troubling is because of what it effectively does. It says to terrorist organizations, you have the initiative in the armed conflict. For anyone who has been in the military, the initiative is the ability to decide when, where, and how a conflict takes place. You drive the fight, you determine where the next fight is going to be. And everyone at every level of the military is taught, tactically, operationally, strategically, about the importance of the initiative and getting it and maintaining it throughout the fight. What this would essentially be saying to Al-Qaeda, to terrorist organizations, is you have the initiative throughout the balance of whatever conflict you're involved in. Get to Yemen, get to Somalia, get to Sudan. You can't be struck there, and you get to decide where the next battlefield is, whether it's New York or London or Washington, D.C. or Mumbai or Detroit or Bali or Madrid. You get to decide where the attacks take place. And after I told you at the beginning how generally the laws of war treat terrorists, deny them the combatant's privilege, take away civilian immunity, they are the least protected group because of the way they conduct themselves. To then read international law as granting immunity and the initiative to terrorist organizations just can't be squared with the way international law has approached terrorism to begin with. And for that reason, I would say that the boundaries of the battlefield should continue to be viewed traditionally, that the tools of armed conflict can be used wherever the participants in the armed conflict can be found. Thanks.
All right, so I'm going to take this from a little bit different perspective. We're not going to actually gouge each other's eyes out. I mean, if we argue about anything, it's which service is better, the Army or the Navy. I think we already know the answer. We already know the answer to that, don't we? Yes. So what I thought I would do is look at the Al-Awlaki case as well, and look at some of the legal issues that arise from that, and go back to an issue that seems to be recurring throughout this war on terror. And this is the question of what kind of paradigm are we in? Are we in a war-fighting paradigm, or are we in a law enforcement paradigm? And the answer to that question is really significant because it drives a lot of questions. And I think the Al-Awlaki case in particular raises some of these questions. So I'm not sure I'm going to take a position one way or the other, although I do have some opinions. But so more as to maybe lay some of these issues out for you so you can see how the parties in the Al-Awlaki case could get to the positions they get to. And then maybe think about what's the best structurally under our system of government, under our constitutional structure, what's the best way to resolve these issues? Or if we're, for example, concerned about unbridled executive authority, what's the best way to cabin that authority? So, first of all, as an outset, and I think Professor Lewis has done an excellent job of raising some of these international law issues and the law of armed conflict issues. But I think it's also useful to go back and ask ourselves just some basic questions with regard to Al-Awlaki. What's the difference if we were to treat this as a law enforcement paradigm, where he is in Yemen, versus a law of war paradigm, or an armed conflict paradigm? Well, if this was a law enforcement paradigm, if he was just a criminal out there trying to do bad things to the United States, and we treated him criminally, we don't get to prejudge and execute criminals before trial. I mean, that's not our system of justice. We have to provide some basic due process protections, including bringing them to justice, capturing them if we can. Police officers, for example, they don't get to use force or use deadly force initially to target and kill suspected criminals. They can only use deadly force in some kind of a defensive way. But otherwise, their responsibility, their obligation is to capture them, to bring them into U.S. control, and provide them a trial in which we determine factually whether what they did is a crime, and if a crime has been committed, what kind of punishment that they would get. So Al-Awlaki might claim that, hey, I should be treated like any other criminal, and therefore you can't just target me without these basic due process rights. And in essence, that's, although that's not exactly what the ACLU is arguing, that's, I think, the end state that they're hoping to get to, is some kind of system that we treat him as a criminal and provide those protections accordingly. On the other hand, if we treat this as an armed conflict, then a completely different paradigm applies. And Professor Lewis has alluded to some of this, but In essence, what happens is the law of armed conflict, if we are in an armed conflict, that law, the law of armed conflict, replaces it. It's what's referred to as lex specialis. It's its own set of laws that govern the conduct of the combatants. And within that, with respect to targeting, which is really the issue that I would want to talk about under the law of armed conflict, if we are operating under that paradigm, then we don't have to bring a Lockie to justice. If he's a legitimate target under the law of armed conflict, then the obligations of the United States or any other combatant are to ensure that they comply with principles of necessity, that this is a necessary target, that they comply with principles of proportionality, that the response isn't disproportionate to the military objective that they're hoping to obtain, that they can appropriately distinguish or this target, this lawful target, from civilians who cannot be targeted, and that they abide by principles of humanity. And that's all that would be required if we're operating under that paradigm. And certainly that's the argument of the Obama administration and the Bush administration before them with regard to predator strikes in general, and even in the case of Yemen, which is somewhat separated from the battlefield in Afghanistan and separated from the battlefield in Pakistan, that because this is an armed conflict, these are the due process. These are the principles that apply. We don't apply a due process analysis. We apply a straight armed conflict analysis. So what Al-Laki in essence claimed was, no, that there's something more here. And interestingly, in that case, in the oral arguments that took place between the federal judge and the parties, one of the issues that he kept coming back to, and it's an interesting issue, is, if in order for the United States to listen to wiretap a U.S. citizen overseas, some basic due process protections would have to be applied. So how is it that if the United States has to apply with some basic due process protections to wiretap a conversation by a U.S. citizen overseas, how is it that due process protections don't apply if we want to target and kill them? I mean, the judge was clearly troubled by that kind of incongruous outcome. But interestingly, and perhaps not unsurprisingly to those who follow these issues, the judge ultimately held that this was a political question. This was a question not for the courts, but it was a question for the political branches, specifically Congress and the President. So what authority has Congress given for the President to operate under this law of armed conflict paradigm in Yemen, when you have a U.S. citizen, a dual citizen of Yemen and the United States who's hiding out in Yemen and who's engaging in these activities? Well, the authorization that we point to is the authorization to use military force. It was passed after the September 11th attacks. And if you look at the language of this, and this is the specific congressional authorization, it says the following: the President is authorized to use all necessary and appropriate force against those nations, organizations, or persons he determines planned, authorized, committed, or aided the terrorist attacks that occurred on September 11th, 2001, or harbored such organizations or persons in order to prevent any future acts of international terrorism against the United States by such nations, organizations, and persons. This is broad language, for sure. But as the court has in other cases, and specifically in Hamdi, has noted that this is not a blank check for the President to do whatever he wants. And the ACLU, in their case, I think interestingly, picked through some of this language and said, wait a minute, this is all referring to the attacks of September 11th, 2001. This organization in Yemen, and perhaps Al-Laki in particular, there's no evidence, at least, to suggest that he was participating in September 11th, 2001 in those attacks. So the authorization to use military force cannot apply to him. This organization may not have even existed. Al-Qaeda in the Arabian Peninsula, for example, may not have even existed in September 11th, 2001. So how can you use the authorization to use military force to get to that? I think it's an interesting argument. Now, ultimately, what the court was certainly troubled by, but punted on the issue by saying, well, this is a political question. So this is, and I guess the one position I do take in this debate is I agree that the court is correct. This is a political question. Interestingly, right after the case came out, there was an op-ed in the New York Times that suggested, well, you know what we need? We need some kind of targeting court, like we have a FISA court. In the area of wiretaps, before the executive can execute a wiretap, it has to go through this specialized court, a FISA court. And it's a secret court, but federal judges sit on the FISA court and they make decisions as to whether they are going to authorize or validate a wiretap that already took place. And we should have that same system, according to this op-ed, for targeting decisions. So we should let judges look at these issues and decide, you know, whether the need is sufficient and et cetera. And I vehemently disagree with that approach for a number of reasons. And specifically, this is an area where I do not think the courts have expertise. They are not the body in our political system that has the ability or the expertise to decide these issues, and it would be dangerous, and I think a dangerous precedent, to hamstring the president or the executive in the time of war by having to get pre-judicial authorization to make these decisions. But that's not to say, in my opinion, that there is not a check that can be placed on it. And my argument is more structurally that this is not an issue for the courts, but it is an issue for Congress. And I think it plays back into this paradigm, the law enforcement or the law of war paradigm, is whether or not Congress views or should continue to view the actions that we take outside of Afghanistan, in Pakistan, and in other places like Yemen. Should we view that as a law of armed conflict, or should we view that as law enforcement? And Congress should have a greater say. I think that, in my opinion, that the AUMF is, as broad as it is woefully inadequate to address this issue, because I don't think this doesn't seem to me what Congress contemplated in crafting the AUMF. Although I think the arguments can be made that as broad as it is, that the president can use that authority. But I think the point that I would make is that there is significant precedent, and we might say, well, how likely is it for Congress to really get involved and try to put a check on the executive's power in a time of war? But actually, and Professor Friedman and I have written on this and are continuing to write on this issue, and that actually there are some good examples in this conflict itself where Congress has gotten very involved. And the example that I can cite to most specifically is the Military Commissions Act, which was passed after the court in Hamdan invalidated the executive's military commission system. So what Congress did after that is they held lengthy hearings, and they considered opinions and positions from a wide range and a wide body of interest and individuals in deciding what kind of military commission system ought to be crafted afterwards. And what is significant to me about that as an example, or as a case study, if you will, that this took place while the war is going on. That Congress proved themselves capable and adult enough and competent enough that they could address these issues. And if they thought the president's authority was too broad, that they could check that authority via statute or via congressional authorization. And so I think that moving forward from here, I think that the question that has not been asked enough in the context of drone strikes, in the context of other issues and detainee issues, is exactly what does the AUMF authorize? What did Congress contemplate by authorizing this? Did Congress really contemplate for the president to engage in targeted killings or targeted strikes in a circumstance like Yemen of an American citizen? And if not, does the president have any inherent authority to do that without congressional authorization? And if we the people, and if Congress doesn't like it, they ought not to turn to the courts for a relief, but Congress itself ought to get more involved in cabin the president's authority.
All right. I know you've got questions. Don't make me call on people.
Well, if I could just take 1 minute on a couple of things that you said. That the one issue, because I've argued this and taken much the position that Professor Hansen has in some of these issues, that this is not an issue for the courts. My opponents in these debates have pointed out, rightly so, that it is in Israel. Right? The Israelis have more experience with targeted killings of terrorists than anyone else. And when they have done this, their courts have become involved in determining what should be done. Now, I would say that where they have become involved is on the back end rather than the front end. And I am a strong proponent of getting someone involved on the back end of these things, which means that after you have a strike occur, you have someone independently review to determine whether you got it right or not. And if you didn't get it right, then you need to change your procedures before you do it again. And I'm not aware, although I'm not privy to what sort of internal review the CIA conducts after strikes, but I'm not aware of any specific formalized review procedure that is required. If there is none, then I think there is a role. And I could even see a role for courts in that situation in a ex-post rather than ex-ante decision.
Yeah, well, I think the issue then certainly becomes is what process would be due, and does it necessarily require the court's involvement? Certainly saying, well, the courts can get involved after the fact, maybe, but that obviously we understand that also sets precedent for future operations. And so I don't know that that's, again, I can still see danger in that approach as well, because even we've seen it in Israel as well, that has an impact on future operations, combat operations. But that is an interesting point with regard to internally, what internal checks are there within the agencies, within the Department of Defense, within the CIA, when they engage in these strikes to make a determination. Is that sufficient process of reviewing the target list, how they're developed, what level of authorization is needed to approve the specific firing of a drone? And is that sufficient? Is this, if we were to look at it on a due process analysis, is that sufficient due process in the context of an armed conflict? Unfortunately, we don't know, because the government is not forthcoming with their process. They just tell us to trust them, and that's, we can all take that with a pretty heavy grain of salt as whether they earn our trust in this area. But I see the real problem and the real concern in the area of national security in general, and this area is an example of it, where Congress is all too willing to let somebody else take the heat for the decision and stand back. And this, to me, is an example where if we really are concerned about the president exceeding his authority here, then there is a role for Congress to play.
Has Yemen refused to turn over this Alaki guy?
No. In fact, Yemen has convicted him in retention. So he is under sentence, I believe, life sentence. Many courts have already said that. And they would, I guess, argue that they can't find him, or they can't catch him, or that region of the country. And he was convicted about 4 or 5 months ago. With all that's going on in Yemen right now, it's becoming even less possible for the government to control or capture or find. So Yemen certainly has done what they claim that they should do if they want to remain neutral. And the other thing I would say is that to the extent strikes have gone on in Yemen, most indications that we have are that the Yemeni government has said go ahead and do it. I mean, it's all been with their permission. So they are acting more like an ally than a neutral, and certainly not like an enemy in this case. The one other thing about turning him over, though, Yemen doesn't have an extradition treaty with the United States, and the Yemeni Constitution prohibits the extradition of a Yemeni citizen for trial overseas. And so even if they were to sign an extradition treaty with us, they'd have to amend their Constitution if they're ever going to hand him over to us. But under the laws of war, they're not really required to hand him over. They're just required to get him out of their country or to intern him.
So if they've already done what they said that they can do, and they're trying to, put him in jail or execute him or whatever, if they didn't want the U.S. taking him out, wouldn't that be an act of aggression against Yemen?
Yes, if Yemen is saying we are neutral, and he is under sentence, and we are trying to get him, you may not use the tools of armed conflict on our territory, we would have to go along with that. My understanding of it is that his government, that the Yemeni government has said, go ahead. You know, if we catch him, we'll hold him, we'll do whatever. But if we don't catch him, you're free to go ahead and use the tools of armed conflict on our territory, and I believe that's their sovereign right to do so.
That issue is played out more specifically right now in Pakistan, where the authorization by the Pakistani government for us to, and we're doing many more drone strikes in Pakistan than we are in Yemen, but the issue there is, are we doing them with the permission, with the tacit permission of Pakistan, or with just their acquiescence, or publicly they say one thing, do they say something else privately? I mean, that issue is really coming to play in Pakistan in particular.
And the one danger of relying on consent, of course, is that consent can be withdrawn at any time. If that's the basis for us conducting drone strikes on other territory, it has to be with their consent. If that's the view we use, then the danger is they change their mind and say you can't do it anymore. The other theory, and Harold Coe, the Office of the Legal Advisor, gave a speech at the American Society of International Law last year on drone strikes. And he talked about sort of two different theories under which these can be conducted. One would be what I've just described, permission. The other is a self-defense theory, saying that if they are not doing what they need to do to prevent harm coming from their country to us, that we may be able to strike into their country in self-defense even if they don't give us permission. And he didn't really explicitly say which of these he is using, or we are using currently. But the one thing WikiLeaks did was at least it showed us that with regard to Yemen, we have permission. We clearly have permission because some of the Yemeni cables were leaked, indicating that, yeah, we're going to tell our people they're our planes, but you can go ahead and do this.
So. And with in this issue of self-defense, and the government has kept it, I think, intentionally vague as to what authority they're using, so that they can use whatever one I think fits their view of the situation. But in this context, there's this notion of anticipatory self-defense, that it's a broader concept perhaps of self-defense than you would see in regular criminal law, where you can't go down and shoot somebody because you think tomorrow they're going to kill you. I mean, that doesn't work under a law-fighting paradigm, but it may work under a law of war paradigm, under this notion of inherent right of self-defense, and including anticipatory self-defense.
So doesn't that make these strikes dangerous, with having to rely on the consent? If it's withdrawn, that we could run the risk of becoming criminals for crimes of aggression, and then if we're using that that self-defense, that anticipatory self-defense theory, then doesn't that make us feel a little uncomfortable, because that was the similar justification that the Germans used in World War II to invade France or Poland, that they were fighting threats to their people?
I wouldn't talk about the German example as being anticipatory self-defense. The best examples of anticipatory self-defense are Israel in '68. They fired the first shot in the war because Egypt, Syria, Jordan had massed on their borders and were getting ready to go, and Israel fired the first shot by taking out the Egyptian Air Force on the ground. And that was viewed as being a legitimate example of anticipatory self-defense. It wasn't self-defense because nobody had struck them yet, but they said the anticipation was clear enough that that was all right. Then there are other examples of self-defense which have been less clear. Israel striking the nuclear reactor in Iraq. That was largely criticized. I mean, Saddam was very clear that he'd be willing to use it on Israel. That happened in the 80s. But that was criticized as, hey, it wasn't that imminent a threat. That wasn't really self-defense as such. And there are a variety of other attacks like that. But no, I would be very cautious about using anticipatory self-defense any more than you need to. And I think I would much rather go with consent. If the other side says we're withdrawing the consent, then we have to stop doing it. But that's their sovereign right.
So what's the process to get on the list? Like how narrowly tailored is it?
You think about getting on the list?
Well, do you have someone in mind?
Well, that's a great
right.
idea. Yes, you have somebody in mind. Going to submit some names. Well, that's a great question in terms of what process is there. I mean, with al-Awlaki, the two events that we can link him to, at least somewhat indirectly. One, the most dramatic is the Fort Hood shooting, that the Major Hassan claimed to be motivated by al-Awlaki's, his propaganda, so to speak, and his view. So what the process is, it could be as well whatever grabs the attention of the executive at that time. We don't know the process. I mean, that has not been published, and that is trouble, right? Because we want to think that they're acting appropriately, but if we don't know, and if they're not going to disclose that process other than to say, trust us, we're being very careful about how we do this, that becomes a slippery slope. Just like anything else can become a slippery slope. What's the process of making you an unprivileged belligerent or an enemy, unlawful enemy combatant? Well, today's definition may not be the same definition for tomorrow. So that is trouble. I mean, that is, in my opinion, it's an area of concern that I think requires greater congressional involvement in terms of how those decisions are made.
The other thing al-Awlaki was involved in, the Fort Hood shooting, and to be clear about what it takes to be or not be a combatant, merely propagandizing is not enough. You can't become a continuous combat functionary by being Joseph Goebbels, or by being a radical imam who's saying Muslim faith demands that you go commit jihad. That's not enough. But with Major Hassan, apparently, and they haven't released the email, so we don't know for sure, but he was in direct email contact with Hassan before the shooting. And even more importantly, I think, Abdul Muttalib, the underpants bomber from Detroit, said that al-Awlaki had planned and orchestrated that operation as well. And so the reason why he was where he was, ready to blow himself up over Detroit on Christmas Day, was because al-Awlaki had directed and got him there. And I think that's a much clearer continuous combat function if al-Awlaki is planning and orchestrating operations like that.
Do you think we should have any different framework for targeting U.S. citizens versus non-U.S. citizens?
Generally no. If they, and you go back to World War II, or take John Walker Lind, right, the American Taliban in Afghanistan. We could have killed him just as easily as captured him, and we don't have to check passports before we go after the enemy. And the same thing, we killed a lot of American citizens who had gone back and joined the German army, and the German Americans who had returned to Germany in 1939, 1940. And in 44 and 45, we killed them throughout Europe and North Africa without figuring out who American citizens were or weren't. And so, in that sense, once you're in, and that's why the law enforcement, law of war paradigm line matters. Once you say we are in a war, I don't care whether you're an American citizen or not, if you are identifiable as the enemy, and that'd be the other thing. How do you identify? But once you're identifiable as the enemy, you're just as targetable whether you're a citizen or not.
Yeah, I would tend to agree with that, and I've made similar arguments using the World War II analogy that the fact that somebody was an American citizen, that in itself should not entitle them to a different level of protection than the law of armed conflict. So for me, it gets back to the issue of what authority initially does the president have to do this, and that's where the focus ought to be to answer some of these questions in terms of definitions and the like. Because if you don't answer them, if it's gray there and if it's not clear there, then it's problematic down the road. The clearer it is and the more precise the authorization is, then I think it's less of a concern.
I think the situation is pretty easily distinguished from that, though. There you've got battlefields, a traditional battlefield with large combat forces intermingled in that on the German side were some U.S. citizens. Here we know well in advance that we do have a person who is subject to some of bears the privilege of some of the protections that we afford our citizens. And yet we're deciding whether or not to preclude him from those protections, from taking refuge behind those protections in advance. It's kind of one, we're talking about a reactionary battlefield situation in a very traditional sense. Here we're talking about a very targeted and premeditated sort of attack on one person using one drone in a known situation where we're refusing to grant him protections that a citizen would normally have.
Well, I think that gets to the point that Professor Lewis is raising, and is raised over this issue, is, well, where exactly is the battlefield? And you use terms like, well, the traditional battlefield versus non-traditional battlefield. I think is what you're alluding to, and I think that's a challenging issue, and that's where I think a lot of the debate is with respect to this, is where does the law of armed conflict apply? Does it apply just in limited geographic regions, like a World War II force-on-force engagement? But even there, we can think of examples that went outside that particular battlefield realm. Or does it follow the individual combatants? Does it follow the backpack? Wherever you go, wherever you take your backpack and your tools of war, does it follow you there? And that's a tough question. The nature of terrorism as a threat makes that a difficult question. So I agree with you that in some ways it's different, but in some ways it shouldn't be that different. If we say that that it fits under the law of war paradigm, then to me it shouldn't matter. So it gets back to the fundamental question first of how are we going to define the battlefield? And if we define the battlefield that broadly, then I think it's an easier question.
Do you apply that same argument to the issue of denying him his constitutional protections because he's known, he's in an unusual situation of being known to be a citizen?
Well, let's go to a World War II scenario and assume we have a soldier who decides on the battlefield to defect and go to the other side. We all know him. He's Private Smith, and yesterday he was fighting for us, and he just went across the lines, and now he's fighting for the Germans. Can we target him? Can we kill him? We know he's an American citizen. Absolutely. We don't have to give him a trial and any due process rights because the law of armed conflict applies. The mere fact that we know he's a U.S. citizen, I'm not sure that matters. I don't think that's ever mattered.
And another example would be Admiral Yamamoto. Yamamoto was not an American citizen, but had he been, right, he was killed well away from the traditional battlefield as an individual who we identified, and then we sought him out and shot him down. I don't think it would have mattered if he was an American citizen as long as we know he is a member of the enemy. The real question is, how do you know he's a member of the enemy? What Professor Hansen said is, what are the standards? How are we deciding that this person meets that? But if we accept that process has been completed, and you say he is now a member of Al-Qaeda, or he is now dangerous enough to be considered Al-Qaeda or whatever, then I don't think his citizenship matters. And I think one of the ways of figuring that out, absent knowing what the CIA is specifically doing, and to the extent judges are doing this already in the habeas cases, you have a fairly robust set of criteria now where judges are saying, if you do these things, we're going to deny your habeas petition because you were clearly a member of Al-Qaeda. If you did these things, that's not good enough. And so you do have a list of factors that receiving military training is good enough, staying in a guest house is not, and that kind of thing. And then you sort of totality the circumstance and say, okay, he belongs in that category. Now it doesn't matter if he's an American citizen or not.
This is Professor Lewis. This is more a question for you. International jurisdiction. I have a friend who works for the G3 shop in SOCOM, and they're saying that they're talking about maybe using anything from Ravens for non-lethal targeting up to Predators and Reapers for lethal targeting in Colombia for like drug lords and stuff like that. Since they're not armed combatants against terrorists against America, how does that apply to the law of war?
The only way that we can use those assets against people in Colombia would be if the Colombian government authorized us to, first of all. So we'd have to have their permission. And then if we have their permission, I don't think It would depend on how Colombia views them. I think the way that it would work would be if you say the drug lords and the people being targeted are part of the FARC or are related to the FARC. The FARC are in a non-international armed conflict with the government of Colombia, so they are a rebel force that is fighting in a non-international armed conflict. If we are asked by Colombia to join on Colombia's side in that non-international armed conflict, using the tools of armed conflict in that context, I don't think is troubling. But that's the context it have to be. I don't think that Colombia could just say, we have a drug lord here we don't like, he's a bad criminal, we can go get it. And where this is going to come to a head pretty soon is Mexico. Is when does that cross the line from saying it is a bad law enforcement problem to it is a non-international armed conflict?
And I think that question raises, again, this whole issue, the slippery slope of, I mean, you know, we hear the terms war on terror, war on drugs, war on whatever, war on poverty. I mean, does that allow us to now use a armed conflict paradigm as opposed to a law enforcement paradigm because we now call it the war on drugs? And again, I think that gets back to the precision of the authority that the president has and gets from Congress to do those things. But I would say that generally speaking, without something more, that seems to me to strike more along the law of enforcement paradigm, rather, and particularly if he's an American citizen down in Colombia doing this, that seems to me, without something more, that's a law enforcement paradigm. AUMF doesn't cover that. At least, I don't know right now.
Yeah, I would agree that AUMF doesn't cover that.
At least that's what we're arguing. Well, let's see. Somebody from the executive may argue differently.
Are either of you concerned about the definitional disparity between a functional combatant and a terrorist? Because a functional combatant seems to be a rather broader definition than terrorist and could include a number of different individuals, for example, that were, I don't know, people who are fighting in Libya for right now, who are fighting against their government, or people in Saudi Arabia who are fighting against their government. If we were an ally of the traditional government, what are the possibilities that we end up treating them as terrorists as opposed to revolutionaries, and does that fit underneath this paradigm as we're speaking of it now?
The one thing, you know, the whole, whoops, the one statement that you hear repeated again and again, one man's terrorist, another man's freedom fighter, that doesn't hold water, I don't think. And because you just look at who they target and how they do it, and that determines whether they are a freedom fighter or a terrorist. You can argue that the people in Libya are freedom fighters because we're on their side, but if they are targeting civilians, then they're terrorists. We may like them, we may want them to win, but if they are going and actively targeting civilians, as opposed to military members, then they're terrorists. And if they are sort of following the laws of war generally, if they are only targeting military objectives and using proportional force to do so, then they are not terrorists. They are, but if they're in a non-international armed conflict, then their government would view them as being criminals that could be, you know, arrested. They don't get a combatant's privilege, in other words. But to say that they are, I think the line between terrorism and being a revolutionary, an insurgent, whatever, is that line between who you are targeting and how you're going about doing it. I don't know if that answers the question or not.
No, but
no. Well, then.
Well, I'm just concerned because there's this wide. It seems like there's a wide definition, which is
okay. Well, I think maybe I can get to your question. Not every terrorist is a functional combatant, right? Mm-hmm. So, for example, our underwear bomber that flew into Detroit, and we captured him. He fell under the law enforcement paradigm, even though he's a terrorist. Why?
Because he wasn't attacking a state.
Well, he was attacking. He was starting to blow up a plane.
Well, I guess he was taking actions against civilians.
Okay, but so are members of Al Qaeda, right?
Right.
So I think you raised a really good question. What makes somebody just a terrorist for law, and then we're going to fall into law enforcement? paradigm versus a terrorist or a combatant that we're going to target under the armed conflict paradigm. There is not a bright line to that question, and I think that is one of the difficult things here. And certainly, the president, the executive, has made a number of policy choices about when he wants to treat them as terrorists, or treat them under a law enforcement paradigm, even though they're terrorists, or treat them as combatants, and that we're going to target them with drones. And maybe it seems to me about the only principled way we're doing that so far right now is whether the attack happened in the United States or if it happened outside the United States, right? Mm-hmm. Is that good enough? Is that a principled distinction, or is that just a distinction of convenience or of political reality? I'll leave you to decide that question. But I think I don't know that your question can really be answered. Now we know what the significance of calling somebody a combatant or losing the privilege of a protected person because they engage in these warlike acts is that we get, if we're under the law of war paradigm, we get to target them and kill them. We don't have to take them to trial and all of those kinds of things. But I think you're trying to find bright line distinctions that do not exist.
As Professor Hansen said, and as students in my national security class know, in domestic law, there is no one definition of terrorist. There are actually, how many are there?
Many.
That's the A student right there.
There are many. And as Professor Hansen said, it is often a matter of convenience which definition the executive branch is using at any given time. We have time for one more question.
If we switch over to the sort of law of war paradigm, how do we define success and no one is over? Because it seems like under the law enforcement, success would be, capturing them, bringing them to trial, putting them in jail, or not. But how is there an end if we're just sort of perpetually at war against an enemy that doesn't come onto the traditional battlefield and probably aren't going to surrender even if they're down to their last few?
Right. Well, the wars. The traditional ways of ending a war are not available here. That's very clear. There will be no signature on the deck of the battleship Missouri. You won't surrender. But I think that you could look to, for example, Northern Ireland, where you had whether you would call that an armed conflict or not, and I think most people would probably say it never quite got to that level. Or you can look to Israel and Hamas. I mean, Israel and Hamas have been at war for 40 years. The FARC and Colombia have been at war for 40 years. Sri Lanka and the Tamil Tigers were at war for 25 years. Now, the Sri Lanka-Tamil Tiger War ended. It ended in a horrible, bloody, nasty way, but it ended. And you can say that it's ended when the people that were engaging in terrorist acts ceased to do so. Right? The war between Colombia and the FARC will end someday. It may be because the FARC are crushed. It may be because the FARC are given some territory to live on. It may be because the FARC decide to engage in political discourse and, like Sinn Féin, get involved in the peace process in Northern Ireland. Could be any one of those things. But the answer is the war ends when the bombs stop going off.
And I think that question has relevance in other contexts as well, and one in particular with regard to detentions and indefinite detentions. And that's an area that has gotten a lot of attention recently in Guantanamo, where the president just signed an executive order recently setting forth a process by which they can continue to detain individuals who will not face military commissions, will not face any form of tribunal. Under the laws of war, the notion is you can detain your enemies until the end of the conflict. Well, when that end is ill-defined, and we don't know when that could be, and in essence, a detention in Guantanamo may equate to a life sentence without any process beyond the habeas or the combat status review tribunal process. That's a troubling question. It's not one that can easily answer. And I think one of the issues that you should take away from this discussion a little bit is that terrorism has proven itself a challenge to apply with traditional concepts, legal concepts that we've been using up to this point. I'm not to suggest that they don't fit, but I am suggesting that when you hear the debates out there, much of that debate, the source of that debate is because the paradigms that we use now don't quite seem to account for the situation we find ourselves in with respect to terrorists in many regards.
All right, please join me in thanking our guests.